Finally, the United States Supreme Court has ruled that discrimination based on sexual orientation or gender identity is prohibited under Title VII of the Civil Rights Act of 1964. What does that mean for wedding professionals and their LGBTQ employees? Today on the podcast.
This is the Wedding Industry Law Podcast, a podcast dedicated to wedding professionals that are just trying to keep it legal. And now, your host, Rob Shank.
Hey out there, welcome back to the podcast. Such an interesting episode, very happy episode. The reason why it's so happy is because I'm going to be discussing a United States Supreme Court case that outlaws discrimination based on sexual orientation and gender identity in the workplace. But before we get into that and what wedding professionals that employ LGBTQ employees need to know, I have one ask. Please like and subscribe to my YouTube channel, Wedding Industry Law. I will be your best friend. You can even hit the bell for notifications. It's not just the podcast that you'll find on my YouTube channel, but you'll find other informative videos like hot takes on recent court cases and things of that nature. So please like and subscribe. Also comment while you're there. Again, be your best friend. So we are going to be talking about the United States Supreme Court case, Bostock, and the compendium cases with that and what that means for wedding professionals going forward. But we're not doing that alone. We're going to have a employment discrimination attorney, Crystal Kesler, on the program. Crystal is an excellent employment discrimination attorney. She's litigated in both state and federal courts, discrimination and wage claim matters. She's defended corporations, businesses, insurance companies on one hand. On the other hand, she's represented individuals in personal injury claims, in discrimination claims. She's done the whole deal. Crystal has been selected as the National Black Lawyers Top 40 Under 40. She's a proud member of the State Bar of Georgia, the Georgia Association of Black Women Attorneys, the Atlanta Bar Association, and the National Trial Lawyers Association. And she's also a very good person. She is the COO of a nonprofit called the Love Project 404, which provides voice to the voiceless by helping the underprivileged facing incredible hardships that are rooted from systematic racism and cultural biases. And I think that racism and cultural biases is the whole reason why we even have to have these Supreme Court decisions. So we're so happy to have her here. Crystal, welcome to the show.
Thank you so much for having me.
Excellent. So, Crystal, I'm so glad that you've been able to come on to the show to talk to us a little bit about essentially the importance of this case and actually these cases, because there are kind of like what we would call the compendium of cases. So the court didn't just hear one case, they heard a couple, but the importance of these cases and what that's going to mean in terms of employing people of differing sexual orientations and transgender persons going forward, and how we can be inclusive of these individuals and, reduce the likelihood that we as employers are going to discriminate and be sued for discrimination. So that's kind of the point of having you on today. So, but to start off with, Crystal, though, could you kind of talk about the main case, which is the Bostock case? Can you tell us a little bit about the facts of that case? I know it's a hometown case for you and I know that. So
yes,
just let us know what that's about.
Sure. So, ultimately the courts made a decision, like you mentioned, on a culmination of a couple of cases. And the reason that they needed to do that is because you have different jurisdictions, different circuits who have essentially taken similar facts and decided totally opposite things. And so there's no continuity moving forward. And so that's why the Supreme Court decided to take this case on to figure out, all right, how are we going to handle this report for everybody across the United States? And so with the Bostock case, the main thing was that he was a government employee, essentially a semi-government employee, who had done amazing things for the organization. He had been sort of one of their top people in the organization. And he so happened, after years of experience with the organization, to join a gay softball club. And just by virtue of doing that, they found him, they fired him. And they claimed that the firing was based upon, I think they coined it behavior unbecoming of an agent, right? So they received some complaints, and so that was the result of those complaints. And so that was sort of the basic of the original case, the Bossett case that originated here in Georgia. And then there were several others that they sort of culminated and put together for the court case, including an additional one where this individual was transitioning genders and decided to inform their employer that they were transitioning genders, wanted to give them a heads up, sort of that they would go from he to she in terms of pronouns and moving forward, and would fully live their lives as female or as a woman moving forward. After informing the employer, the employer's response was, yeah, I don't think this is going to work out. And so they ultimately terminated her as well, based on that. And then I believe there's a third one as well.
Right. The ones that you just mentioned are the primary movers for at least for today's episode. So if I understand you correctly, what we have is an individual. He's a homosexual man who was fired in Clayton County, Georgia, because he wanted to join a gay softball league, which is it's such a crazy thing to in terms of privilege. Like I would never have to worry about that. And I love my attorney softball league. You know what I mean?
Right.
Be fired for wanting to play softball. And anyway, so he's fired for wanting to join a gay softball league. And it's some type of, what's the word? I don't know, like pretense. That the pretense is that, well, you did this stuff over here, but it's actually because you're a gay dude. And then
yes.
with the other case, this is an individual that informed the employer that they were transitioning and fired. And correct me if I'm wrong, I'm not a discrimination lawyer, but this is essentially the Supreme Court was hearing the case on the grounds of what's called the Civil Rights Act of 1964, which prevents discrimination in the workplace. Can you kind of elaborate on that?
Absolutely. So yes, and so the short term for that statute is essentially Title VII. So if you ever hear people say Title VII, that's essentially the Civil Rights Act of 1964 that really deals with employment and the discrimination in the employment workplace. And it protects against discrimination against individuals based on race, sex, national origin, religion. Disability is another piece that's sort of Title VII-esque, but it has its own ADA claim. And so they all sort of fall under this big old umbrella of Title VII, where you can't discriminate on those principles. And so the Supreme Court case was really geared towards the category of sex and what does sex mean and what does that encompass. And so that's really what they were delving into to determine who qualifies as a protected class underneath that category of sex.
Right. So I guess, in other words, do you discriminate against someone whose sexual orientation is homosexual based on sex, literally in the statute? Like you can't discriminate based on sex. Okay, does that mean that you're discriminating? I typically, or at least in the past, have associated that with gender, right? Or
That's right.
Sex is female, male, right? But no, like now we're having to this sex also include homosexual or sexual orientation, right? So that's an interesting thing. So I guess at the end of the day, what happens?
Right. So at the end of the day, the Supreme Court determines that sexual orientation is considered a part of sex discrimination. And so if you are discriminated on the basis of your sexual orientation or your transgender status, that is discrimination and that is protected under Title VII. And so, to take it a step back to understand what was protected before this case, maybe, and then what is now protected, to understand the difference is that before, as previously mentioned, it really was gender discrimination, right? It was if you were a female and you were treated differently than the men in the organization, you could sue for that, and vice versa. If you were a male being treated differently than the females in the organization, then you could sue for that. And then the other part that was sort of the gray area for us as attorneys was gender nonconforming. Right? Because that was something that even before you get to the sexual orientation piece, where you had what some would consider butch female, or females who did not adhere to what others would consider, feminine dress or feminine attire. And it wasn't, we're not talking about, cross-dressing, right? We're not taking it that far into the spectrum. But just someone who only wore the button downs and the pants as opposed to a skirt for a woman, just to give an example. And so you had those issues where you had to decide that, is that gender discrimination, right? Because she is not getting treated like the other women would be treated, simply because she doesn't conform to what people have identified as what we consider feminine. And so that piece was the gray area, and there was some law that still supported, protecting that piece, but it didn't take it the step further to sort of really deal with the real issue and the root of the issue, which is, sexual orientation, right? And so we had to be very careful. If we said you discriminated against her because she is a gay or lesbian female, right? That wasn't protected before this case. If you said that she was discriminated against because she didn't conform to your norms based on gender, based on her being a female or a woman, she did not conform to those norms, that maybe may have been protected prior to this case.
Right.
And so now we have a little bit more clarity that all of that is going to be covered and protected.
Gotcha. Okay. Before we move into okay, well, what does this mean in terms of moving forward and inclusivity in the workplace? What I think is interesting about this is this was a 6-3 opinion. Okay.
Yes.
And you have justices lining, I don't know why my Google Assistant wants to help me with everything, even though I never say, I don't even know how the program works. It's calling out for me for some reason, wants to help with the episode. No. Gorsuch is, I guess, what you would call a textualist. And so he's going to read a statute how he would read it, like an everyday person would read a statute, right? Even if it might have been written in 1856. He's not going to give account to what the people were saying that wrote the law, or what the community was saying at the time that the law was wrote, right? Which I guess would technically be like an originalist, I guess is how you define that in terms of judicial interpretation. So you got Gorsuch saying, a traditional conservative dude, who's saying, all right, well, my rule on interpretation is I'm going to read the text, and if the text is unambiguous, this is how we're going to roll, right? And I thought that was really interesting. This, particularly the conservative judge, is coming out with the liberal part of the court only because of the fact that this is a statute. Number one, not the Constitution, it's the statute, and the statute says no sex discrimination, right? And that's literally what he based it on. I thought that was a really interesting concept. Whereas you have Thomas, who's, I guess, more stringent originalist, and his thing was the people that wrote this in 1964, 9 out of 10 of them probably couldn't tell you what transgender means, so therefore it can't be encapsulated by sex. I just thought that was just an interesting aside from a wonky attorney spot. But anyway, okay. So Crystal, tell me then what you can actually start, if you wanted to, but what are some basic things that a wedding professional that has employees can do to be inclusive and prevent discrimination, even if it's unintentional, even if it's not like, oh, you want to play gay baseball, you're out of here. I'm talking about how can we be the best employers for these awesome people that want to work for us, right? Does that make sense? What can we do?
Absolutely. Number one, to the extent that you have already in place some policies or procedures concerning, or a policy in place regarding equal employment opportunity, right? If you have one of those clauses or one of those policies in place, if you need to update that to include sexual orientation. If it doesn't already, some people have already placed that in. Like I said, depending on where you live, it's a gray area, right? And so it's always been a part of your policy. And you're in the South, if you're in Georgia, maybe not, right? And so you do need to update those to include sexual orientation so that it is in black and white, very clearly stated, whether that is on your website, whether that is in your handbook, or both. I would suggest both.
That's an excellent suggestion. I don't mean to cut you off, but for the people out there that might not know what this means, can you talk us a little bit of what is a policy and procedures? What is it, and why is that important in that regard?
Sure. So number one, when you're talking about what is the policy is simply the statement on how you will operate in this area or this arena, right? And so the policy for an equal employment opportunity policy simply states we will not, discriminate on the in our hiring practices, in our promotion practices, on the basis of, and then you fill in the blank with those individual things that are listed, those categories that we discussed earlier: sex, race, gender, sexual orientation is what we're adding to it now, religion or national origin, things like that. And so you want to make sure that you've listed out every one of those categories, and you can easily find those online. You can easily go to the EEOC.gov website, and they'll list all of the categories that are protected under Title VII, and just make sure that all of those are listed in there, right? So that's number one.
I gotcha. So I guess if I understand correctly, then it's not just to be an inclusive environment. This is something that you would have in writing that shows, in case you were accused of of conducting yourself in a discriminatory fashion, you could say, well, we have a policy, and this is whatever this person did or the agent did is against our policy. We are not the person that you're saying that we are, right? It kind of like
Right.
It's an extra defense notch, aside from the other benefits of like, hey, we're trying to be good.
Absolutely. So that's step number one, is just to have the policy, the black and white written out rule. Number two is the procedure, right? And so the procedure is separate from the policy. The policy says we will not do this. The procedure says what happens if someone says that we did, or an employee complains that we did. What is the procedure, or the policies, or the steps that we need to take to investigate and ensure that we are confirming that either A, it did not happen, or B, it did. Right. And so to the extent that it did, what is our response going to be? And so that just sets you up ahead of time, right? We're just planning in advance of something happening, because you never know. And so that is what we want to do when we say policies and procedures. We're not just saying it just to say two different words. We really do need both in place.
Right. Okay. So having a good policy and then actually executing it, doing it.
That's right.
You mentioned a little bit about handling complaints. Can you talk about that? Why is that component important? Like, if someone is, hey, listen, I think that you're not being inclusive right now, and I think that you're singling me out, XYZ, and then having that, complaint trail, why is that important?
Paper trails are very important in employment cases, right? And I will tell you, I don't think this will change, even with the change from this case. I genuinely don't see the 11th Circuit, where we're talking Georgia, Florida, and Alabama. I don't think that the 11th Circuit will change its trajectory, if you will, in how much credibility they give employers. And because of that, I think it's important that employers have those policies and procedures in place, because if they can show that A, they have the policy, B, they have the procedure, and C, that in this particular case with this particular individual who has filed this suit, they followed the policy and the procedure to the T, you're going to have a sure-proof defense to get out of the discrimination case. And so you have things called the Elgar Allen defense, which is really technical, no pointing into all of that, but having those policies and procedures essentially protects you. It's a sure-proof protection, against some of those claims that are coming forth. And it may not keep them from filing the suit, but it protects you during the lawsuit, and you will likely be successful in a summary judgment motion if you have those documents in place and procedures properly followed.
Gotcha. So, Crystal, you had mentioned a minute ago the EEOC has potentially has resources for employers with regard to being an inclusive environment. Can you talk a little bit more about that? Like, can you download forms, or like what's available there, and what is the EEOC?
Sure. So the EEOC is first and foremost is the administrative piece of the government who handles and enforces the Title VII laws. And so what that means is that before one of your employees, let's say you have a disgruntled employee, they think they were terminated on the basis of, let's just use sexual orientation, right? Since that's what we're talking about. They were fired because of their sexual orientation. What they will do is they have 180 days from the date of incident, and that typically will be the termination date, the suspension date, something like that, the negative employment action date. They will have 180 days from the date of that action to file what we call an EEOC complaint. The EEOC complaint is going to essentially say who they are, who you are as the employer, and they are going to list out the incident, right? Just a basic, this is what happened, and I believe that I was discriminated on, and there's some boxes you can check, and you check, and they will check as the individual what boxes they believe, what category that we discussed, race, religion, that they believe was the basis for the discrimination. Once they've submitted that, the EEOC will investigate these claims. As the enforcement group, they will investigate these claims to determine whether or not they believe that the employer has violated the Title VII. Depending on where you are, the investigations are thorough or not. You never know. But just understand, as an employer, they do have a right, as the EEOC, they do have a right to come in and interview your employees, your current employees during this investigation, to interview you, to make site visits, and to do so, without notice. And so, those are things as an employer you should know. And so they can do those things. And then once they've completed their investigation, that's the first check mark in an employee having the right to file a suit. Once they close, the employee will receive a letter indicating the closure of the file from the EEOC. And that letter also means that the employee has 90 days from the date of that letter to file suit.
Wow. Okay. So, wow, there's a lot there. Just real quick, it seemed to me that you indicated that it depends on where you live, on how thorough of an investigation there will be. And I'll do you one better, and maybe you can speak to this.
Sure.
But we've been talking about the Civil Rights Act of 1964 is federal legislation. So that's the law of the land, of regardless if you're in the mountains of East Tennessee or you're, in the deserts of Arizona. Now, that's not to say that a state can't have more protections for classes of people based on sexual orientation. So if you might live in a state and this had no effect on you because you already had protections under state law, your jurisdiction. But like Crystal and I are saying, in Georgia, unfortunately, the times have not caught up with us yet. So we needed this Supreme Court case. So yes, there are going to be states where, if you were in that class that are now protected under the federal law, you already had that anyway. So you've got the EEOC that investigates these claims, and if there is a potential claim, then the aggrieved party can file a lawsuit, and then it's a whole can of worms with that. So with regards to wedding professionals that are still listening to this, you've got the option of doing the better ways, the recommended ways of protecting yourself. Is number one, be inclusive. Number two, be inclusive by having policies and procedures that would include transgender and persons of different sexual orientations, and then making sure that it's not just paper, right? That you're doing what you need to do, and then finally having open channels of communication. So if there is a complaint, you're on it and it's documented. So Crystal, in the last couple minutes here that we have, what are some other things that, and based on your experience, because you do this, you sue people for discrimination. So like the floor is yours in terms of like, what are some other things that, that people can do to protect themselves, and what are some things to do that, like, don't be a jerk, you know what I mean? Like what are some recommendations that you've got?
Sure. So one of the big things I think is going to become more relevant based on this case, which means we're all protected under sexual orientation discrimination, is that we're going to start dealing with pronouns, right? And so it is proper to just ask, what is your proper pronoun? And they won't be offended by being asked that. Individuals who may or may not go by he or she, they may go by they or them. And so if you want to be truly an inclusive environment, right, don't be afraid to ask those questions so that you can better understand. And then just don't treat them any differently because of that, right? And so, what a lot of employers, will try to do when people are uncomfortable, they'll just shy away from it, right? If I don't know, I don't know, and I don't need to know. But unfortunately, from a legal standpoint, that's not going to necessarily protect you, because there is this sort of thing, and we haven't seen this play out yet, obviously, since the Supreme Court just, implemented this new rule. But you have, for instance, under the ADA, where you can be discriminated against because you have a disability, or you can be discriminated against because you are perceived to have a disability. And so similarly situated, if you sort of take that same context into the sexual orientation realm, now you have a case of, I didn't ask about their sexual orientation, so I didn't know that they were gay or whatever. But did you, right? Was there some sort of tell sign for you that whether they are or not is irrelevant, but that you believe them to be? And was that sufficient for knowledge in terms of being on the basis or having enough knowledge to say, you know, this person discriminated against me, they knew about my sexual orientation or believed me to be?
That's interesting. Because I mean, like,
Yeah.
I feel like, I mean, we're all in this together, but I can see both sides of this, where if I walk up to somebody and go, what do you want to be called? Unless I'm doing that to everybody, I'm presuming this individual, you know, requires that question. The same if I went to somebody that, as an employer, went to somebody that's maybe looks ethnically different than me and go, hey, what are you? You know what I mean? Like,
Right.
I don't, you could be Italian, I don't know, you could be Jamaican, have no idea. But like the fact that I'm asking you that versus somebody else, I feel like opens up a can of worms. This is going to be, I don't know, like, it's going to be interesting to see. I'm just glad that we had the law of the land now. Um,
Yes.
but
It is. It's definitely going to be a gray area and a learning process. But I really do think that if, you know, we've gotten to the point where our employment applications have all of this information, right? We ask for people's age, date of birth on their applications, right? Age discrimination is a real thing, right? But we ask the age anyway.
Yeah.
And so I think we're going to ultimately have to just say, all right, let's just put it all out there. Yes, we knew, but we didn't do anything as a result of that. And if you put it on the application, you send that application to no matter who they are, and let them sort of select how they will. And I think that's probably the safest way to do it, is to put it in black and white and just to say, you know, here it is. The second thing that you can do as an employer, though, I think, to help with some of these things is that you need to have an HR in place. HR is in place for this very reason, because what the courts will look at with employers is, HR knew because they have their application, right? But did the manager who terminated them know?
Right.
You can't fire somebody for a specific reason if you didn't even know that fact underlying that specific reason, right? And so if you have the principles, the policies, the procedures in place, and you keep sort of a wall up of information, we already do it with regards to medical information, right? With FMLA, things like that. Everybody doesn't have to know what your FMLA leave is for, right? They may know you're on leave, but they don't know why.
Gotcha.
And if they don't know the underlying why, they can't discriminate against you because of this specific disability.
Wow.
So same thing. Let's, you know, so we can implement it that way as well, to protect ourselves and make sure that we have the hierarchy of, you know, organizational charts, so that it's very clear who has access to what information.
Oh my goodness. Yeah, there's so much more. It's so interesting that we can like split these hairs so many ways. And if you'll indulge me, a long time ago, I was having to give a presentation on what you can say and not say in an interview to French businesses in France that were trying to open up in the United States. And what was interesting is that they were so confused about why they couldn't ask, hey, are you going to get pregnant anytime soon in the interview? But they had no problem with like Holocaust denial being a criminal offense. So like there was the interesting cultural clash of freedom of speech. Like, well, we're America, we should ask if you're going to get pregnant, right? But like, it's just, this is a topic that no, you're not protected from if you cross the line, right? So anyway, I
Absolutely. And even beyond that, pregnancy discrimination is a thing too. That's a part of the ADA. It's actually a thing.
Go tell the French people that are trying to open up subsidiaries in the United States. But Crystal, you've been extremely helpful to our audience in breaking these things down. We really, really appreciate you coming on the show. We're going to have to get you on the show again to kind of like unpack policies and procedures and that kind of stuff. I think that'd be
absolutely
very helpful in the future. Thank you so much.
Thank you. Thank you for having me.
Awesome. I don't mean to wonk out any more than I need to, because this episode has already gone pretty long. But I did want to highlight one excerpt from the majority opinion. So this is Gorsuch's opinion. And it's one of those things where it's like, it's 2020 and we're just now getting to this rationale as appropriate in this situation, which I think is so strange, but it makes so much sense to us Now, where were we, 10 years ago, 15 years ago? But I'll leave it to you. I'll leave it at this. And this is a quote from Gorsuch's majority opinion. An employer who fired an individual for being homosexual or transgender fires that person for traits or actions it would not have questioned in members of a different sex. Sex plays a necessary and undisguisable role in the decision, exactly what Title VII forbids. Those who adopted the Civil Rights Act might not have anticipated their work would lead to this particular result, but the limits of the drafter's imagination supply no reason to ignore the law's demands. Only the written word is the law, and all persons are entitled to its benefit. We'll see you next week, guys.
Thank you for listening to the Wedding Industry Law Podcast. This podcast is intended for general information only. Nothing in this podcast is intended to be legal advice. Do not rely on this podcast for your legal matter. Instead, consult an attorney in your area. Thanks, obrigada, até semana que vem.